Yes.
Or 3 seconds. Could you ask a very important question? I want to put it on. What is a valid election? A valid election is one which is unchallenged. One. Or where challenged, one where a final judicial pronouncement is made on it.
Okay.
We should take this forward.
Last week, around the table here on Newsfile, there was what I discovered to be near unanimity. That one, you say what? Unanimous NF. That is
FC.
Newsfile. Even among the lawyers, that the pending process in the Supreme Court, Seserarai, appears to have a very strong chance of success on the basis of the date of Gazette. And the date of Gazette looked at against the date of filing the case in court. Now, do you share the view that when all these matters were pending, Parliament should have been slow, and what the Supreme Court has done now is the best way to keep sanity, to maintain sanity?
So you have boxed a lot of questions into one. A lot. And let me say that I agree entirely with the submissions of Dr. Kojo Asante when he says that it is not common sense, but it's the presence of gaps in the law that has caused this problem. I hear many people talk about patience, patience, patience. How do we define that patience? And when do we invoke patience as a remedy to a lacuna? And how long can we be patient? So you need to identify the gaps in the law and deal with the gaps, rather than throwing it out in the air. Because the idiosyncrasies does not actually represent the law. Okay, we want things done a certain way, but is that what the law says? To get everybody to understand that when a matter of this nature arises, this is the procedure. Is the reason why we have regulations or the CI.
Judicial pronouncement.
You understand? Or a judicial pronouncement. Because all of us have opinions on what should have been done. I agree. And you know, on your platform, I said it. Sometimes they say that we are too legalistic on this platform.
The law is everything.
But that's the law. When they were hoofing and puffing in Parliament and drumming tables and throwing papers across the aisle, I said that was not the solution to the problem. I said it on your network. I said the solution to the problem was that Article 1125 had been invoked. And when you read Article 1125, Doctor, it suggests a chain reaction.
A trigger point,
And so, if
once the clerk has issued within 7 days,
that one,
the EC is compelled.
So what do you do as a lawyer? The options that you have is to arrest the process.
That's all.
That's all. So it was not to drum tables and ask for.
You said this. You said the solution is a judicial solution.
It's not a political solution. Now tell me, how do you get a constitutional provision reversed by writing a letter to withdraw an act? How do you get it? When that person has triggered a power under the Constitution.
Or holding a press conference.
Or holding a press conference.
Or holding Parliament to ransom that they shouldn't
You understand? But politics has taken over. And I agree entirely with you.
But Inusah Fuseini, their plea, was it a plea? It was a demand. Was that the Speaker should cause a withdrawal of the notice that has been sent to the EC. So if the Speaker had acceded to their call, they would have achieved something.
Well,
Yeah,
but
but-
does the Speaker have that power in the Constitution? That regiment.
The Speaker should be minded
And even
about
they
what's
should,
going on.
they should be minded by their standing order. So if there is room within the standing order
Orders.
to change the way in which the trigger happens, then it creates scope. But it has to be by law, because
law.
that certainty of law is
By which law?
important.
Whoever originates a process has the power to withdraw same.
Well, that process is backed by law. He didn't trigger the process by his own personal wishes.
It's a mandate.
It's a mandate
You
given
have
to him.
do it.
He has to do it.
Do it.
Okay.
Do you understand? So let's come to the
And the court stopped Parliament
to do what?
from declaring.
The court has
Well,
done
at least what they have, yes, what
Yes.
they have.
that. The court has done that.
Oh, wait, so you see, at the time when the matter was filed in court,
Yes.
I know there was no stay or whatever it is.
Yes.
Did the Speaker have room to be mindful of what was going on in court and hold his hands?
That's an opinion.
I'm asking you.
No, that's an opinion.
Because you see, that's what I'm saying.
that
In
is
the
why I'm
processes
saying
of
that
state,
our idiosyncrasies does not constitute the law. Read the Constitution carefully. Read the Speaker's ruling on the 7 days. It's even captured in the Constitution.
no, you are not going where I'm going. See, not everything
Bentil
is
is
written in
talking
law.
about the exercise of discretion.
Yes.
In a way that demonstrates wisdom and appreciates our security situations.
And-
Because as we understand,
Yeah, fidelity to
Kpandai is a
assistance.
security situation.
So you see, that's the problem. All of us know as lawyers that where discretion is not regulated by law, it's subject to abuse.
But that's why, Inusah, you are a
All of
very
us know
seasoned,
that.
you are a seasoned lawmaker. Inusah,
You are here, sir.
Inusah,
That is
we are in
why-
the realm of opinion, and we should do this. Your words will have a lot of weight. In this situation, would it have been proper for the Speaker to say, I am constrained by these things, and therefore nothing will go amiss if I hold my hand in deference to the courts?
I'm not saying that the Speaker could not have said that. If the Speaker had said that before the letter, that would have been okay.
So please let me stay on this. See, I have said, and I repeat, Speaker Babin is my favorite speaker of the whole Fourth Republic. Why? He takes decisions. He makes moves. He goes into spaces which are controversial. You see what he wore for his own swearing? He breaks the mold. So for me, that's what makes him my favorite speaker. This is one of those gray areas you are not sure, where he should have made one of those iconoclastic decisions and said that, look, we have, hold on, let me finish. We have 3 arms of government.
Yes.
The Supreme Court, Parliament, and the Executive, and they all have their powers, but they have their limits. And in all of these things, when there's a constitutional issue, it is the Supreme Court I defer to. I will make law. But when there is a matter before the Supreme Court, I will defer to them, just like I would like them to defer to me in other places. It is not written in any law. But this is how you form these kinds of agreements. If he had done that,
Speaker's intervention, when prematurely Yindam was being pushed out of the house,
yes,
was in full compliance with our law.
correct.
He said,
But he was
7
guided by
days
law.
automatic stay.
Yes.
After that, processes, if appeals and processes have been filed, they have the potential
Of success.
of stultifying the process.
Yes.
So what he did was in full compliance.
Correct,
with
but
law.
that one he was
You are
guided
saying
by
you
law.
should go beyond the law.
He was guided by law. I'm talking about where there is no clear law.
No,
Where there is no clear law.
There's clear law here.
About
There's
if
clear
something is
law.
before the Supreme Court.
Except that the lethargy of the courts delay the process. So let's get the things clear. There's clear law here. Let me answer your question before I come to the clear law. So the certiorari application in Parliament stands on 2 things.
Certiorari application in the Supreme Court.
Stands on 2 things. A supposed Gazette notification that was issued on the 24th, and another alleged Gazette notification that was issued on the 6th. Now, so you see, that right of the petitioner to go to court to challenge an election results or the validity of an election rests squarely on Gazette notification. It is what triggers.
Which was the matter?
It is what triggers the rights. And we know in law, where statute confers a right on a person and provides the procedure, you not only have the right to take advantage of the provision, but you are also compelled to follow the procedure. That is actually what the rule of law is about.
Yes.
No problem.
Okay? Now, so why is 24th December relevant? 24th December is relevant in this particular matter because if the Supreme Court says that 24 is the date of the Gazette notification, then the action of the petitioner in the Tamil court is statute barred. The case, and you know the decisions of the courts, the case will not be concerned with the merits, whether the elections were legitimate or not.
So statute barred, let's explain to our audience. It will mean that the time that the NDC candidate, aggrieved, approached the High Court, it was late and there was no rescue. So his case will be voided.
Yeah.
That he couldn't have gone to court.
Not at all.
But
And
if
so-
he computes the date of the Gazette from the 7th,
From the 7th of
6th, right?
Of January.
January,
Yes.
then he will be within time. Right.
Thank you so very much. So you see where the decision of the certiorari application will stand. It will stand on whether or not the January Gazette notification is the proper notification. Does it dispel, revoke, or, replace the 24th December notification? Because both of them will have consequences.
The law's requirement is that in an election petition, like in this matter, you have 21
1 days.
There is
After
no
the-
extension for you. 21 days. We didn't wait to bring your grievance to the court. If you allow a day to pass,
You are gone.
Okay.
So
let's
you
go
see-
to
Who made that mistake?
Yeah.
The Gazette
I'm not
mistake.
finished.
You were actually on the floor, sorry.
So the High Court, I've said that this matter could have been resolved. You see, when the decision was given in the High Court, I listened to the parties carefully, the lawyers. And all lawyers do that. Those who have practiced before, when you are going to court, you don't know where the judgments will go. Sometimes you prepare your
Notice of appeal.
Notice of appeal and stay for execution. Because without notice of appeal, you can't file a stay of execution. So you prepare and hold it. When you go and it's in your favor, you shelve it. It's just like an election. When you prepare a concession statement as well as a victory statement, and then when you win, you pull out your victory statement and read. So the parties told us that look, they had when they were going to court, they thought that the election, the judgment would not go in their favor, so they prepared. Immediately upon the pronouncement, they filed a stay of execution.
Notice for
Notice of execution and coupled their, and filed a stay of execution. I thought that they ought to have pressed the court to have the time fixed immediately after the 7 days. Immediately after the
You can press as you want. If they don't mind you, what do you do?
That is the thing. So if you press as you see again, so you are coming to the political. If you press as you want, and the court is not doing what is proper and just in the circumstances, then you have reasons to complain.
By what you're saying, you belong to the school of thought that unless there is an order, express order, a stay of execution does not stay the hand of the victim.
But then I also concede that if the stay of execution is served on the party has a duty to respect the processes of the court.
Okay.
I also belong to us. I recognize that. So again, the question is, was the stay of execution served?
At least it would have been served on one of the parties, which is an office, very easy to go serve.
Is that
The
so?
Electoral Commission.
But electoral commission doesn't do. You see, that's the thing.
It's a party. It's a second defendant.
But it doesn't do anything in the process. Their trigger, their action is almost at the tail end. That's why they don't even appear to court. The court was not happy.
Yeah.
They didn't come.
Which I thought was not proper.
they see themselves as being the.
But these matters are very
Don't be now a defendant.
serious.
Okay, but
You understand?
So this is not the first time.
I agree. The court
No. We should speak to it. See, me, where I haven't gone is this. I said, who caused all this trouble? We are.
In the Electoral Commission.
It is the EC. And look, it is important that we keep referring to the
It's
EC.
fair to say it is the EC.
It is the EC.
The elections were going on smoothly.
It is the EC.
Then they are going to do a coalition, and party people start. These people, their security is not even
If
senior.
they had published polling station results
sure.
the way we have
and
asked,
then we say blame EC.
No, I'm not even on that.
Every
level.
step of
I'm
the
not
way.
on that level.
Yes, on their
On the
arithmetical, mathematical error.
Why?
Fine,
No,
but
you see,
the conduct of the polls, the conduct of the polls,
But
the
all of
collection
us,
of the results,
all of us saw
arithmetic error.
all of us
who
saw
has
how
duty to protect
party
the integrity
people,
of the-
sure, all of us saw how party people made coalition almost impossible in some of these
The EC, with all that they have, cannot tell us that they didn't have the wherewithal to manage that.
Particularly the NDC.
Ask for
Where the NDC not matching their army to
Didn't they have the
coalition center.
the state law enforcement, including the army, to deal with that?
Who has the primary responsibility
Yes,
of
primary responsibility.
of the integrity of the election?
If they can't do it, they should
No,
tell
but
us.
on the security, that one you can't put it on the.
No, why
Who
not?
has integrity of the election?
That's why that one. I agree with.
Makojo, why not? Why not?
Not
They can have 100 army
No,
people
but you
there.
have
Okay,
a national-
we have one more person who
This
has not
keeps
spoken.
repeating, and then we didn't come to
Let's go to.
As for that one, I don't.
Let's hear Alfred Choyeboa.